Tinubu was not even a defendant in that case. That will shock you, right? It will shock you, but go back to the documents. It was an action in rem, not an action in personam.
So Bola Tinubu was a defendant in that matter.
The account, yes, he is a defendant because he's linked. You see, the owner of the account and the account are like two siamese twins. They are umbilically bound. That's why even if you look at that, when the accounts were, established as defendant, they say belonging to Bola Tinubu. And when the court said that the defendant be asked to come and show reason why it should not be finally forbidden, who are the people, the defendant the court is talking about? Digits, account number comes to court. No, the owners of the account should come to court. And Bola Ahmed Tinubu did not contest. He, in fact, cooperated to release it. This is where he cannot separate himself from the account.
If you look at those documents too, Asiwaju Bola Tinubu was not mentioned as a defendant. People have skipped that. It was only account numbers that were mentioned, and at the end of the day, they just said account numbers in the name of Tinubu. That is all. Not that Tinubu was a defendant. It was accounts in his name, not him. Those accounts were sued, not him. It was action in rem.
Who is the owner of the account? How do you separate the owner and the account? Do you know the doctrine of confidentiality that exists between a banker and a customer relating to the account? Without an order of court, the bank does not have any right to disclose the details of a financial transaction. That is how inseparable your account is with you. And so when the account was joined as a defendant, by the time the ex parte order was granted, the court said, let the defendant come and establish why it should not be given the final forfeiture. Who are the defendants? The owners of the account.
There is no charge. There was no charge. There was no indictment. There was no criminal process. It was a purely civil process against those accounts.
Money laundering, dealing with narcotics are criminal offenses set out by separate laws in the United States. The US government introduced what they call non-conviction-based recovery. Because the way they operate is, if they are going to prosecute you on a crime that investigation suggests, they are going to spend a lot of money. And whatever is the proceed of crime that they are targeting, they may not be able to get a hold of it until the conclusion of the trial. But because under non-conviction-based recovery, the idea is to recover as fast as possible the proceeds of crime, they now apply what we call the forfeiture proceedings. Forfeiture is a civil proceeding. Yes, it is, not a criminal proceedings. But the elements that are argued before the civil court under forfeiture proceedings are elements of crime. It is like election petition tribunal. It's a sui generis. It is just the proceedings that is civil, but the ingredient upon which the prosecutor will convince the judge that this asset and this asset and this asset are proceeds of crime under the laws of Illinois are criminal offense, criminal elements.
No. A forfeiture, you see, that's why I said you should take a paper and a biro. This is a lecture class for you. And I want you to pick a biro and a paper to begin to take notes, because I know you are a student, a law student. So this is also a lecture session for you. Take a biro and paper.
In fact, when he was fighting you yesterday, he was very unprofessional, quite frankly, because in our discipline of law, you don't look at your colleague, whether he's a student or a lawyer, and say, take pen and paper, and I'm teaching you. Very insulting.
Let me just be a little immodest. Immodest in the sense that I'm not just a lawyer, I'm not just a member of the inner bar, a senior advocate. I am one of the most experienced criminal prosecutors in this country. Private prosecutors, apart from one or two persons who are private prosecutors, who were also, former, graduates in quotes of Gani Fahimi, I have done more prosecution, like I said, apart from one or two, more prosecution as a private prosecutor, private, in the entire country today. Up to the point I became a minister, a day before, I was in court prosecuting on behalf of the Economic and Financial Crimes Commission and other law enforcement agencies. They have hired my services over the years. So my prime area is criminal prosecution. So I can say this with all aplomb and confidence, apart from being a fellow of international arbitration. So nobody can teach me anything about criminal procedure.
And once you're losing an argument, we experience that sometimes in court. Once someone is losing argument in court, the next thing you do is you now descend into legal gutter to begin to challenge. There's no basis for you to say, apart from two prosecutors in Nigeria, there's no prosecutor that comes. One, unprofessional because it's champatious. Number two is it's patently false because you will count 30 prosecutors in Nigeria, you will not get to him.
Because you see, with a trained eye and the trained eye of a prosecutor, I read every line one by one. I've done this more than 10 years ago and came to the conclusion that Shiwaju had nothing to do with this. Because I read this thing more than 10 years ago. So I read it with a trained eye.
Consistently, he used the term, I used my trained mind, trained prosecutor. Who trained him? He worked under Gani Fawehinmi. Gani Fawehinmi was, throughout his life, not known as a prosecutor. He was a human rights defense attorney. And when he said, I'm using my prosecutory or my intelligence or my prosecution mind, there are certain things a prosecutor looks at whenever he's confronted with a case. Number one, the fact pattern. And number two, inference. A man who was brought to the court, his account was brought to the court. At the time, the prosecutor's mind I'm talking about now, where was he working? How much was he earning? How much was the amount that the prosecutor sought to
So that
seize?
there's the question mark on the source of the money.
So that's what a prosecutor thinks. I'm suggesting to his prosecutory mind. If the prosecutory mind is functional, these are the thoughts. How much was Bola earning? How much he was earning, even if you multiply it by a number of years, the prosecutor will say, is it enough to have that large sum of money?
The issue is not a new issue. So let me first of all say that. You saw some blogs or some news sites, online sites, making those normal wild introductions like breaking news, just in, fresh facts. No. Those are not fresh facts. They are not new issues. These issues have been in the public domain for more than 20 years, and the issues have been sufficiently addressed and dismissed.
Their first quarrel is that this thing happened 30 years ago. It doesn't matter if it is 100 years. If you are vying for a public office, you must be willing to be scrutinized. The reason is because the man who will become the president of the Federal Republic of Nigeria, that's why they have what they call security vetting, must be somebody that the nation have an idea of his life from when it started to where he is today. So he does not become an object of blackmail or a national security threat. So the fact that it came after 30 years is a non-issue.
You're saying forfeiture is not a punishment, but don't you think that it's a penalty? I mean, for you to forfeit, is it not a penalty?
No. Penalty is, penalty is when they take something belonging to you and they say, look, they are imposing a fine or penalty on you. Forfeiture is that, look, this thing we think is our tax. Look at paragraph 38 now. They say it's tax. What belongs to them, they are just taking out, so you can go.
Actually, but in law, was that a forfeiture? One.
Yes, forfeiture.
In law, that forfeiture, is it a penalty?
Yes, it is. You are forfeiting what rightfully you would have argued as your own. Why are you forfeiting it? Because investigation proves a link between you and that item, and that the item relates to narcotics. So narcotics and money laundering is a criminal offense.
Well, forfeiture is not a fine, I don't want to refer to you again. When I say I'm educating, this is like a class we are having. But I don't, for all those who think, for law students everywhere, who think forfeiture is a fine. Fine is a punishment. Fine is a consequence of a conviction. Fine is a consequence of a criminal trial. So fine has nothing to do with forfeiture. Forfeiture is a civil process. It's a complete civil process to say, well, we are not even going into trial at all. The state goes into forfeiture proceedings with individuals just for the purpose of getting their monies. It does not mean you have committed a crime. You may have not fulfilled your obligation as a citizen regarding financial payment, just like tax. You have, at that point, he had not fulfilled his financial obligations regarding the deposits that were made there and the interest on those deposits. And so they say, well, you know what? Out of these 10 accounts, we are going to take our interest. And for them, tax is oil, is their oil. All over Europe and America, don't play with their tax. So they all say, well, we are going to take our tax because you deposited this money here, you were taking interest on it, you've not paid tax on those interests. So if you look at paragraph 38, that is the crux of the whole thing.
Mm-hmm. Was Bola Tinubu indicted?
Yes, indictment is an allegation. There's a difference between conviction. Yes, he was indicted. But was he convicted criminally? The answer is no.
Because he didn't go to trial.
Pardon?
It did not go to trial.
Yes, so under non-conviction-based recovery, there are three types of plea, right? There is a plea of guilt, there is a not guilty, and there is no contest. If Bola Tinubu, at the time that indictment was brought before the judge, decided to contest it, it will go into full trial, and if the elements are proven, it may lead to his prosecution. What most defendants do in the US is that they don't want a situation where they will be further exposed. So they can afford to let go of the asset. That's why they enter what we call non-contest, what they call nolle contendere in under Latin, that you're not contesting. You're not saying, I am not guilty, I'm also not contending. So whatever you see, you can just carry it. But here lies the issue, and Nigerians must know. It is the moral burden that the nation is confronted by. Somebody who has not denied, has in fact cooperated with the government of Ulines, right, about a proceed of crime traceable to his account. Because if you look at the document, and I think, Sean, if you give me 1 minute, you understand that.
Go ahead.
3 separate documents. There is one that is the affidavit. The affidavit set out the facts and what the prosecutor was seeking to achieve. Number 2, there is a verdict. The verdict is the finding of the court. So the affidavit established a probable cause, and the verdict says that the probable cause has been established under the relevant laws, that those assets that they were seizing were actually proceeds of crime. What they do under non-conviction-based recovery is that once that ex parte application is moved, the judge must say that the defendant be put on notice. Who are the defendants? If you look at that proof of service, which is another document, you will see United States of America as plaintiff and Bola Tinubu as a defendant.
The man is an indicted drug money launderer is not in argument, but convicted. No, I don't believe that is the case. There is an indictment and there is money forfeiture based on a no contest plea by Mr. Tinubu himself, but he didn't go as far as the conviction, as far as I can tell.
Let me refer you to section 137 of the Constitution 1D, subsection 1D, which says that a person under a sentence of imprisonment or fine for any offense involving dishonesty or fraud by whatever name it's called, or for any other offenses imposed on him by any court or tribunal, shall not be qualified to contest for the office of the President of Nigeria. In view of the forfeiture and the settlement that Bola Tinubu had in the United States, as a senior advocate of Nigeria, what are the legal implications of that circumstance, considering the section 137, subsection 1D of the Constitution?
It is not. That constitution you cited, Shehu, is completely, totally inapplicable. It has nothing to do with forfeiture. It has nothing to do with that.
On a final note, what is your summation on this matter?
I am afraid that the conclusion of this case is that from the eyes of the law, especially if you look at the constitutional provision you cited, Bola may be disqualified from contesting.
By who?
No, if the matter goes to court, interpreting that provision of the Constitution, because the finding in that civil forfeiture proceedings has ended against him. That's why he forfeited that. And narcotics and money laundering, whether in America or in Nigeria, is a criminal offense.
You can't look at this in isolation. And I say you can't look at this in isolation, especially in the light of what the High Court just said, that the man has to come and defend the case in the High Court here, seeking to disqualify him. There are plethora of allegations sufficient to have allowed any right-thinking person to have withdrawn from the race. But the man has persisted. So if we are now dealing with legalese, which is different from morality, if we're dealing with legalese, the reality is that you cannot ask him not to run solely on the basis of an indictment to which he had pleaded no contest. If you're looking at the issue of certificates, forgeries, the issue of a lack of provenance or pedigree, where did the man go to secondary school, primary school, what happened in the first years of his life, like he disappeared, like Jesus disappeared for the first 12 years, those are valid questions, but they can only relate to morality. They are not issues of legality. It is we as the people who have to decide whether that is a character that we want representing us as a collective, as a people. Is that the Nigerian president? That is the point because if we pretend not to know, the rest of the world are well aware of what we are fooling ourselves not to see. So it's a function of moral suasion. If people are persuaded that they have no problem with having a person of questionable character as the president, that's their call, really. That's sometimes the ugliness of democracy. But when it comes to the issue of if that is sufficient as a bar, I do not believe it is.